I think you need to read it.
Good evening, friends. And
It's fine.
once you find that your close friends are coming there to join what we started the journey in 2020, I have seen that the closer friends like earlier Tanu Bedi and now Dr. Deepa have started accepting our invites for the different sessions to make things easier, simplified, and in a structured. In the usual routine, I just asked in the baton to take over the session. But today, Dr. Dheeraj Chawla is also there. So I will ask Dheeraj to just say a few words, and then Dr. Deepa Singh will explain the rights of a convict. That because normally one feels that though we speak of the fundamental rights as enshrined under Article 21, but what is the journey forward? What are the rights? Because that will make the convicts understand and facilitate their legal rights to be taken up forward. Over to you, Dheeraj. It's fine, ma'am. You take over the session. We will ask Dheeraj to continue.
Okay. Thank you, Vikas ji, for giving me this opportunity. And as you rightly said that we are celebrating 75th years of Constitution, so it's better we should talk about the rights of convict also, because everybody talks about the right of victim, and we talk about the rights of under trials, like they have a right to fair trial, right to documents, and right to legal aid. The list is endless. But what I've seen in my profession, that once the accused is convicted, after the conviction, usually after some time, he's forgotten by everyone. Initially, family, friends, relatives, even the lawyers. Once the appeal is filed, and even lawyer is not in touch with the accused, because we know that appeal is take lots of time. So at this platform, मुझे लगा कि मैं कुछ सारे मिथ्स भी ब्रेक करना चाहूंगी. इतना अच्छा ये प्लेटफॉर्म है, because when I talk to jail authorities, police, and non-legal person, they have this one misconception that life means life. And when we send a life convict to prison, he should be remain in jail forever. And if he is coming after 14 years or 10 years or 20 years, so उनका मिसकंसेप्शन ये है कि जेल में रात और दिन जो है वो दो काउंट होते हैं. So it's not that. So coming to the main point, like FIR is registered, accused is arrested, trial is given. After the pronouncement of judgment, and we send that person to the jail. So after the court premises, once he sent to the jail, वो वाली जर्नी जो मैं उसकी डिस्कस करूंगी, राइट जो है उसके, जो हम कहते हैं कि फंडामेंटल राइट्स है, आर्टिकल 21, सभी जानते हैं कि no one shall be deprived of his life and liberty except the procedure established by law. And after lots of judicial debate, it is settled that in Menka Gandhi's case, that procedure has to be just, fair, and reasonable, right? And not only that, there is another facet of this Article 21, which says that right to live with human dignity. This is the third facet of this procedure, which is just, fair, and reasonable, and human dignity. So once the person is convicted, he does not lose this very important and sacrosanct right to life. Right to life remains with the convict till the life exists. Right to life उसके साथ एंड तक रहता है, जब तक कि वो जेल में अपना टर्म कंप्लीट करके बाहर नहीं आ जाता. अब देखते हैं कि क्राइम क्या है. क्राइम इज बेसिकली स्टेट के अगेंस्ट क्राइम है, राइट? तभी हमारे क्रिमिनल केसेस जो है वो स्टेट वर्सेस सो एंड सो, स्टेट वर्सेस सो, इस नाम से हम कोर्ट में देखते हैं. सो विक्टिम ऑफ कोर्स अफेक्टेड है, बट जो स्टेट की ड्यूटी है एडमिनिस्ट्रेशन ऑफ लॉ एंड ऑर्डर एंड पीड़ित को राहत दिलानी, पीड़ित को न्याय दिलाने के लिए हम जो है इसको अक्यूज को अरेस्ट भी करते हैं, उसको फिर पनिश भी किया जाता है। पनिशमेंट की भी बहुत सारी थ्योरीज है, रेट्रिब्यूटिव, deterrence, punitive, and reformation, right? So the state has to balance between these three things, that justice is to be given to the victim, at the same time the society is to be protected from these criminals, and we just cannot disown these persons who've been convicted for a crime just that they have committed a crime. It is the duty of the state to send them into prison and reform them. So rehabilitation and after correction, उनको फिर से सोसाइटी में एक रिस्पॉन्सिबल सिटीजन बना के उनको रीइंटीग्रेट करना भी एक स्टेट की ड्यूटी है। तो इसी इन सब राइट्स के बारे में ही हम आज बात करेंगे, बट मेरा मेन फोकस रहेगा चैप्टर 34 ऑफ earlier CRPC, but now Bharatiya Nagrik Suraksha Sanhita. So I will start with the highest form of punishment, death imprisonment. For example, a accused has been awarded death sentence, right? We all know that death sentence has to be awarded in rarest of rare case, and there are guidelines in the various judgment also, right? Bachan se, bachi se, aggravating, extenuating circumstances, all that. But once the death sentence is awarded, what is important that session judge has to, send this reference to the High Court. So during that period, that order will not be executed, because the title of this chapter is execution, suspension, remission, and commutation. So at this point only, I will explain these few words, because in the entire session, then you will be able to understand each and every word in every context. Right? So execution, we all know that किसी भी order को implement करना, effective करना. Suspension, temporarily उसके sentence को suspend करना for various reasons, चाहे उसकी अपील नहीं सुनी जा रही है या कोई और reason है. Then remission and commutation. I will highlight these two words in detail because बहुत सारे लोग इसका distinction नहीं समझ पाते हैं. Remission क्या है? Remission is remitting, short करना उसके sentence को. For example, 10 years imprisonment है, and if in the prison he behaves very well, he's a good, इसका good conduct देखते हुए उसने कुछ remissions earn की है, then remission उसके sentence में से minus हो जाएंगी. Remission means remit the sentence, and commutation is very different from remission. Like in commutation, we are altering the nature of the sentence. For example, death sentence can be commuted into life imprisonment, and in life imprisonment can be commuted if it is like rigorous, it can be commuted to simple, or if it is a simple imprisonment, it can be commuted in a term sentence. What is term sentence? When as a lawyer, we all know that life imprisonment throughout life in God says judgment, prisoner has to be there till he breathe last. But commutation में हम उसके जो लाइफ सेंटेंस को टर्म सेंटेंस में एक फिक्स टर्म के लिए, फॉर एग्जांपल 10 इयर्स या 12 इयर्स या 14 इयर्स उसको डिफाइन कर देते हैं. तो दिस इज द मेन डिस्टिंक्शन बिटवीन रेमिशन और कम्यूटेशन. रेमिशन मीन्स लिटिल माइनस फ्रॉम द whole sentence, and commutation mein we are actually altering the nature of the sentence. So let's again come back to the death sentence. After death sentence is awarded, the murder reference is before the High Court. High Court may confirm or High Court may reverse, subject to the merits of the case. So once it is confirmed by the High Court, then the accused has a right to approach the Supreme Court by way of Article 134, 136 also. And in case of session judge has not awarded death sentence, but High Court in appeal or revision awarded the death sentence, then again he has a remedy to approach the Supreme Court. यहाँ तक हम सब लोगों को पता है कि अपील का राइट होता है, स्पेशली पिटिशन भी है, बट उसके बाद उस बीच में क्या होना है, वो एक तो जब तक अपील का पीरियड ऑफ लिमिटेशन एक्सपायर नहीं होगा या अपील डिसाइड नहीं होगी, उसके डेथ सेंटेंस का वारंट जो है वो एग्जीक्यूट नहीं होगा. So, for example, he has exhausted all his remedies and death sentence is still there. So then session judge will inform the jail authorities and sign the warrant of execution of this death. But here I would like to pause for a moment, because right now it is all the procedure established by law. But in various cases, I'll mention the case of Shabnam versus Union of India 2015. I'll give the citation later on. It is a very beautiful judgment, and I would recommend every lawyer to read it. It's a very, very simple judgment. You can read it as a like story also. In this case, the Honorable Apex Court said that the procedure should be just, fair and reasonable. What does it mean? It means that they formulated various grounds that once the death sentence is confirmed, accused should exhaust his judicial remedy as well as administrative remedies. What does it mean? Judicial review, curative petition, and the mercy petition under the Constitution. So, in death sentences, this procedure has been given substantial sanctity. Like, for example, it's not ordinary review petition. In Arif Mohammed versus Arif Mohammed ke case mein, the Apex Court said that even the judicial review should be heard by the 3 judges, and it should be given, accused should be given the oral hearing, at least for 30 minutes. It's usually the review petition is heard by circulation in chamber, but this judicial review has been given very special treatment when in the case of the death row convict. So he has to exhaust this judicial remedy by way of judicial review, and then comes the mercy petition. But I'm not going to touch this mercy petition in detail because it requires another session. So I'll come to that also in short. So once these remedies are exhausted, then the warrant of execution should be communicated to the accused as soon as possible, and there has to be again a procedure for executing it. There a sufficient time gap should be given. The date should be fixed, not range of dates. That so various other procedural formalities is there to be followed by the jail authorities, and session judge has to keep this in mind. Right. So this is with regard to the death row convict. Then another aspect of human dignity, like this human dignity should be with the accused until he or she meets his or her fate. You know, the regular mental checkup and various other facilities should be available to the death row convict. Now comes to another situation where the death sentence is awarded to a woman and she is pregnant. So the section 454, earlier it is in CRPC, it was 416. It says, if a woman sentenced to death is found to be pregnant, the High Court shall commute the sentence to imprisonment for life. And if that female convict remains in the jail, there comes another extra rights available to the female convict. In R.D. Upadhyay versus State of Andhra Pradesh, there's a list the list is endless. For example, that woman can keep his child up to 6 years of age. 6 years of age child should remain with the mother. एंड फीमेल कॉन्विक्ट्स के लिए अलग से बैरक होगी, अलग वार्ड होगा और अदर एक्स्ट्रा फैसिलिटीज अवेलेबल होंगी. एंड वी नो दैट चाइल्ड व्हेन द चाइल्ड इज बोर्न देयर इज अ लाइक रजिस्ट्रेशन ऑफ बर्थ. तो उस रजिस्ट्रेशन में प्लेस ऑफ बर्थ जो है प्रिजन में ही लिखा जाएगा. And after spending 6 years, he should be handed over to the welfare institutions, which is maintained by the social welfare department. So there are various rights available to female convicts as well. So after that, this is with regard to execution of death sentence. Now we will discuss the newly introduced provision, first time. Otherwise, mercy petition was mentioned in Constitution, but in this Bharatiya Nagrik Suraksha Sanhita, first time I've seen this mercy petition in death sentences cases find mention in the BNSS in section 472, because we all know that regarding mercy petition that there was a like huge delay, there was no proper procedure, and there are multiple petitions at the same time, and no time limit was given. So, and at times accused was also not made aware of this right. So in this newly introduced section 4672, the jail superintendent is under obligation that once the accused की जो अपील है वो डिसमिस हो गई है और सेंटेंस कंफर्म हो गया है और सारी रेमेडीज जो हमने भी डिस्कस की हैं वो एग्जॉस्ट हो गई है, द जेल सुपरिटेंडेंट विद इन 30 days will inform the convict regarding his right of filing mercy petition, right? 30 days के अंदर. And first it will have to go to before the governor and then president. So उसमें भी timeline fix हो गई है कि if it is disposed by the governor, then after 60 days it should be filed before the president of India. And in case of lot of convicts, if a few of them decides that we don't want to file mercy petition, then their name and details should be mentioned in the petition and should be sent to the state government. So this is a very good provision, and it is like I read the section subsection 7. It says no appeal shall lie in any court against the order of president or of the governor made under Article 72 or Article 161 of the Constitution, and it shall be final. And any question as to the arriving of the decision by the president or the governor shall not be inquired into in any court. So it has been inserted to provide a time-bound disposal of the mercy petitions filed before the president and governor, but at the same time, in Upuru Sudhakar versus case, it was held that judicial review cannot be, because we know that judicial review is part of our basic structure. So no appeal, because these are not the governor and president is not sitting as a court of appeal. It's just jisko hum kehte daya yachika. It's a privilege, it's a prerogative of the highest dignitaries or constitutional head. So the accused cannot claim it as a matter of right. So no appeal, but judicial review is possible on very limited accounts. For example, the decision was mala fide, extraneous consideration, non-application of mind, etc. So the judicial review power is still there. But as per section 7, it says no appeal. Challenging the decision of is to be entertained by any. So now I'm coming to the remission and commutation part. So before starting this section, there are there are other ways of giving remissions also. First, by way of statute, which is BNSS and earlier CRPC, and in the jail manual also, and the Prisons Act of 1894 also. How they are different, that we will discuss after this session. So now section 474, earlier it was 433. It says the appropriate government may, without the consent of the person sentenced, I'll read the power to suspend or remit sentence. This is section 432. It says, where any person has been sentenced to imprisonment for an offense, the appropriate government may at any time, without condition or upon condition, which the person sentenced, accept, suspend an execution of sentence or remit the whole or any part of the punishment to which he has been sentenced. And where an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government may require the presiding judge of the court before or by which the conviction was heard or confirmed to state his opinion as to whether the application should be granted or refused. So the section 473 and 474 is the main distinction is that the 473 is talks about suspension and remission, and 474 talks about commutation. So as far as remission or suspension is concerned, these powers cannot be exercised sumoto because the language says this appropriate government may, and on the application. So it means that accused has to move an application, and it may be conditional order, and the opinion of presiding judge who conducted the trial is mandatory. And further, that he should be, he should declare that he is in jail. And if he, on his behalf, his relative files, then they should declare that the person languishing in the jail. So these are conditions, and if the authorities, state authorities, the appropriate governments finds that the accused has violated these conditions, then the suspension or remissions can be cancelled. So this is all about the remission part. Now, section 474, which is very, very important, and I think everyone should understand this in detail. Power to commute sentence. This was in CRPC, it was 433. The appropriate government may, without the consent of the person sentenced, commute a sentence of death for imprisonment for life, a sentence of imprisonment for life, for imprisonment for a term not less than 7 years, a sentence of imprisonment for 7 years or more, for imprisonment for a term not less than 3 years, a sentence of imprisonment for less than 7 years for fine, and sentence of rigorous imprisonment for simple imprisonment for any term to which the person might have been sentenced. So, what happens when the accused sent to jail? So, obviously, we discussed before that he is sent there for punishment also, but it is the duty of the state government that he should be reformed or corrected. So, what are the indicators that he is being a reformed and corrected person? So, in order to give them incentive that they should be reformed and corrected, then these incentives by way of remissions should be provided to the accused, right? So, and state government has their own premature release policies, that if the accused earned sufficient remissions, so Otherwise, remission is, he cannot claim it as a matter of right, but he has a right to claim remissions if he behaves well in the prison, right? So if he earns enough remissions is a precondition to commute his sentence. So I'll give you a very simple example. If a person is awarded death sentence, right, and his death sentence is commuted to life. Life means entire life. But he is in the prison and he has to behave well. So, as per the Prison Act or temporary release of good conduct prisoners, so there are a lot of provision. I will be discussing that in detail. Certain remissions he earns. So then the state, as per the premature policy, count his remissions and commute his life sentence to term. And now, earlier there was no limitation, but in the recent BNSS 474, there is some limitations provided, right? So once he fit into that criteria, then he is released by the prison authorities. Now, in 1974, this section was amended. Earlier section was 433A and now it is 475. This is, I think, the most important section as far as commutation is concerned, because this creates a lot of confusion that if every prisoner has a right to be released on after he spent number of years or earns few remissions, but it's not so. In case death is an alternative sentence. For example, like murder, you may be awarded life imprisonment and or death. So we can say that death is the alternative punishment. Or by High Court or Supreme Court, his sentence of death is already commuted by the High Court or Supreme Court. In those cases, the accused shall not be released unless he spends 14 actual years in the prison. This is important. So I'll come to that also. What does it mean, actual or with remission? So actual sentence is actual days he spends in the prison, or with remissions, it can be higher than the actual sentence at times. So this restriction was on power of remission or commutation in certain cases. And actually, the constitutional validity of this amendment was challenged in Maruram case, but it was held to be constitutional. Now, there is another category of punishment, exceptional cases. So that is, you must have heard, a lot of people must be aware that at times there are judgments that accused should be awarded 20 years, 30 years, and no remissions. So what is that category and under what grounds it is justified? And in various statute also, this, for example, NDPS Act, it is mentioned in one section that accused should not be given benefit of remissions. So उनका impact देखना है कि क्या होगा. So in this exceptional cases, I would like to mention the case of Swami Shraddhanand. It was a case where death penalty was awarded, but while the appeal was before the bench, so death sentence is guided by these rarest of rare principles, mitigating, extenuating circumstances, and a lot of other considerations. But at times, court are also, try to find a balance that, okay, death sentence is too much, but his early release after accepting remissions would not serve the actual purpose. So they have carved out a different special category case that he should remain actual. His actual sentence should be 20 years, 30 years, and benefit of remissions should not be given to the accused. So if it is written in the judgment that benefit of remission should not be given, it should not be given. So in that categories, the accused has to spend the time, whatever is written in the judgment. He is not entitled under the premature release policy. So now there's another debate. Then we'll wind up this particular section of the discussion. That section 477, earlier it was 435. There may be cases, situations like crime is committed in Gujarat. Due to any reason, the trial is, case is transferred to Bombay, or it is transferred to CBI. So, what will happen in case of this appropriate government? So, in BNSS, this word has, they have introduced this new word. Earlier it was consultation. Now they have replaced this word concurrence. So this says state government to act after concurrence with central government in certain cases. The power conferred by section 473 and 474 upon the state government to remit or commute a sentence in any case where the sentence is for an offense which was investigated by any agency, empowered to make investigation into an offense under any central act or other than this Sanhita, or which involve the misappropriation or destruction or damage or any property belonging to the central government, or which was committed by a person in the service of central government while acting or purporting to act in discharge of his official duty, shall not be exercised by the state government except after concurrence with the central government. For example, a case is registered, but in that case, either it is investigated by the central agency, or the central government has the power to make law on that particular subject. Then there has to be a concurrence with state government and the central government. So this is all about the execution, suspension, remission, and commutation. Now we'll discuss the Prison Act of 1894, which is, as per entry 4, list 2, state list in the 7th schedule of the Constitution of India, prisons and persons detained therein is a subject matter listed therein. So the Prison Act 1894 was enacted and adopted by the states in independent India as such. And the section 59 of the Act provides that each central government can make rules. So that's why you have seen that in various states there are different rules and criteria. There are different premature release policies, and the jail manuals are also different. So because it's a state subject, so every state has power to make rules under their own jurisdiction. So in this type and scale of remissions by jail authorities, even the jail authorities are entitled to give remissions, because accused is a very, notorious person. He may create problem in the prison also, and at the same time, prison authorities has to face a lot of overcrowding, lot of problems, because in prison it's a different world altogether. So in order to maintain some discipline and, for correctional measures, so jail authorities have been given this power to grant remissions. So there are three types of remissions as per the Prison Act of 1894: ordinary remissions, special remissions, and state government remissions. Then ordinary remissions is like 2 days per month for thorough good behavior, 2 days per month for industry and other duty. If the prison who volunteers for some work like sweeping, cooking, and night duties. So there are criteria. Then the jail superintendent can give those remissions to the convict, or convict can also earn, right? So and again, if the prisoner completes 3 years of his sentence and is not punished for any prison offense, he shall be granted 60 days remissions for good conduct at the end of third year. Then there is a provision for special remissions also. It may be awarded by the jail superintendent. For example, like जेल में कोई फायर हो गया है, कोई इमरजेंसी सिचुएशन आ गई है, या असिस्ट किया है उसने क्राइम को डिटेक्ट करने में, या डोनेट किया है ब्लड, and there are various grounds like assisting an officer of the prison in case of outbreak of fire or similar emergency, and at times he protected an officer of the prison from attack, then he is entitled for special remissions also. And then again, there is like limit for these for granting these remissions. The total remissions, either it is ordinary or special, to a prisoner under these rules shall not, without the special sanction of the state government, exceed 1/4 of his sentence, provided that in very exceptional and suitable cases that Inspector General may grant remissions amounting to not more than 1/3 of the total sentence. So, however, prescribed that remission granted by the state government under this para may in excess of 2/5 of the sentence of convict. So it means that there's no limit on the quantum of state government remissions. So now, what is the effect of remissions earned on shortening of sentences? So initially, I had explained that remissions is kind of incentive for your good behavior, and there are various rules and there are various sections which authorize, or you can like prisoners can claim their remissions. So वो count होता चला जाएगा. And as per the premature policy, for example, in simple murder case, it's like जैसे बोलते हैं जेल की पार्लनेस में 10/4 की पॉलिसी चलेगी. What does it mean 10/4 की पॉलिसी? 10 years actual sentence and 4 years by way of remission. 4 years means like 1 year has like 365 days. So 365 days into 4, whatever the amount is there, then itni sari remission usko earn karni hai. So then he is entitled for early release, or you can say premature release. Uska case bana ke, there are other procedures to be adopted. But what if another situation? He is there, but he has not earned any remission. If he has not earned any remission, he has not shown any good conduct, he is not showing any characteristics which say that he's being a reformed person, then he cannot be released. He's not entitled for, his case does not fall under the premature policy. So this is the effect of, remissions on the. So जब हम कहते हैं ना कि अक्यूज बाहर आ गया 10 साल में 14 साल में, तो वो डेज एंड नाइट 2 काउंट नहीं होते. बेसिकली वो उसकी रेमिशंस है जो उसको इंसेंटिव के तौर पे दी जाती है प्रिजन अथॉरिटीज की तरफ से और वो एक इंडिकेटर भी है कि हाँ अक्यूज को हमने थोड़ा सा रिफॉर्म कर दिया है, एंड अल्टीमेटली नाउ ही इज फिट टू बी रिलीज्ड एंड reintegrated. He's fit to be reintegrated in the society. So these are statutory and statutory route. Now come to the constitutional right. Again, this Article 72 gives power of the president to pardon, commute, remit, reprieve, respite, any sentence, etc., etc. So I'm not going into the detail. And same time, Article 161 gives power to the governor also. The almost identical, but the only difference that only the President of India has power to pardon the death sentence. Pardon means like completely absolving from the crime. So otherwise, rest of the powers of the governor and president are same, but the only condition that both should act on aid and advice of the Council of Ministers. So otherwise, these powers are unapproachable, unalterable, and they're like no one can, take these powers. No one can ask them how to exercise. But again, judicial, they are again subject to the judicial review. Again, same way for 5 points, if malafide and non-application of mind, etc. So again, now we have remission and commutation in 3 categories. First in BNSS, then in the Prison Act of 1894, and then the Constitution. There is no overlapping. Right? Both are very different. I'll give you a very simple example now by way of, various stages. For example, accused is being awarded death sentence. वो death sentence दिला है. फिर वो हाई कोर्ट जाता है. हाई कोर्ट में भी उसका डेथ सेंटेंस कंफर्म हो गया. सुप्रीम कोर्ट ने भी उसका डेथ सेंटेंस कंफर्म कर दिया. सो या दूसरी सिचुएशन, डेथ सेंटेंस को कम्यूट कर दिया है लाइफ इम्प्रिजनमेंट. नाउ ही हैज टू रिमेन इन प्रिजन थ्रूआउट हिज लाइफ, बट now he's showing certain signs that he is ready for correction, he wants rehabilitation, he is a reformed person, and he earns various remissions as per the availability under the various rules and as per the manual. So if he earns enough remissions and he spends 14 actual years, or they spend actual 14 years in the prison, he becomes entitled for this premature policy. Now, another example, if he he's not earned enough remissions, because there is a limitation on the power of the state to grant remissions, but the power given to the governor and the president is unfettered. So if his case of remissions is rejected or he's not earned, then the governor can grant him the remissions. So this is the whole story after the accused is tried, or trial and conviction and the jails. So I think I have tried to cover all the aspects. If there are questions, I am ready to take all the questions. And any queries?
There's only one query in the chat box. I will ask if Tanu can also be unmuted. Yeah. So before we take the questions, what is your take?
Yeah, Today's, I have to confess very honestly, I was in a session, conference, so I could not hear most of it. I started listening to last 10 minutes and about commutation of death sentence. Deepadi has explained it so easily. मुझे लगता है कि अगर ये थोड़ा अच्छा से और हिंदी में होता तो ये जो हमारे जेल में बैठे हुए प्रिजनर्स हैं उनके लिए भी ये बहुत 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 ही ज्यादा फायदेमंद था. तो इसका अगली बार ना हम ध्यान रखेंगे कि ऐसे टॉपिक को हम प्योरली हिंदी में भी करें ताकि जो हमारा मेन लिटिगेंट जेल में बैठा है वो भी समझ सके. और तेरे को इस वेबिनार को वहां पे भी हम टेलीकास्ट कराएंगे किसी तरह से.
चलो, वो कहते हैं जैसे तथास्तु, तो अभी हम डॉक्टर दीपा को बोलेंगे कि अगर 10 मिनट में इसको शॉर्ट एंड क्रिस्प रख सके तो.
एक चीज मेंशन फिर करना चाहूंगी, मैं भूल गई थी कि जब हम कोर्ट में लॉयर्स कस्टडी सर्टिफिकेट पढ़ रहे होते हैं ना, उनको लगता है कि उनके अक्यूज का सेंटेंस तो फॉल कर रहा है धर्मपाल वर्सेस स्टेट ऑफ हरियाणा, ही इज और सो, लेकिन जज जब पूछता है कि व्हाट अबाउट द एक्चुअल सेंटेंस, सो वो बता नहीं पाते एक्चुअल सेंटेंस एंड द सेंटेंस विद रिमिशंस, राइट? सो आई एम टेलिंग ऑल द यंगस्टर्स और एवरीवन दैट द फॉर सस्पेंशन ऑफ सेंटेंस जो भी क्राइटेरिया है वो एक्चुअल सेंटेंस का है. सेंटेंस विद रिमिशंस काउंट नहीं होगा. एंड इस फ्लो में मैं पैरोल और फरलो के डिस्टिंक्शन बताना और भूल गई आपको. Parole is basically, given for special reasons, or if the person is being granted parole for 6 months or 4 months or whatever, that period is not to be counted in the actual sentence. राइट 6 मंथ उसको फिर एक्स्ट्रा रहने पड़ेंगे अगर उसका एक्चुअल सेंटेंस हम काउंट कर रहे हैं. एज फार एज फर्लो इज कंसर्न, फर्लो यूजुअली is an incentive after 3 years of jail term, that 15 days, और इसमें हम वो conditional release नहीं होता है. Parole is a conditional release for various social obligations, like mention है वाइफ की डिलीवरी है, बच्चों का एडमिशन है, या अब तो एक नया केस आया था जिसमें अलाउ किया कि इसको कंज्यूमेशन के लिए भी इज अ राइट टू procreate, and for that he wants parole. So parole, furlough की distinction, actual sentence and sentence with remissions. So ये बहुत सारा कहीं जगह ना क्लैरिटी नहीं आ पाती है, और जो ये क्लैरिटी कई बार हो जाती है कि लाइक बिल्किस बानो का केस था, इवन द हरिहरन का केस था कि लाइक ट्रायल तो ये गुजरात में हुआ, बाहर दूसरी स्टेट में चला गया, उन अक्यूज को छोड़ दिया गया, तो पॉलिसी कौन सी लगेगी? सो उसके लिए जहां उसको सेंटेंस दिया गया है वहां उस स्टेट की प्रीमेच्योर पॉलिसी में वो फॉल करेगा. एंड नाउ बिकॉज दे आर स्टैट्यूटरी रूल इंस्ट्रक्शंस, तो ये दे कीप ऑन चेंजिंग. सो कौन सी प्रीमेच्योर पॉलिसी के में अंडर वो अक्यूज आएगा? तो एट द डेट ऑफ कन्विक्शन जो प्रीमेच्योर पॉलिसी स्टेट की है उसके अंडर उसका एंटाइटलमेंट है. So if there are yes any other questions?
Dheeraj Chawla has one question. Dheeraj?
Label on the convict is sentenced to life.
Dheeraj Chawla. I can read his question. He says, how much is the maximum remission that life convict is entitled to?
Pardon?
How much remission is the life convict entitled to?
Life convict?
Yeah.
As per the jail manual, the limit is provided in that, and remissions का जो है अगर life convict है उस पे या और किसी पे कोई ऐसी लिमिट नहीं है. The only limit जो 475 में मैंने डिस्कस किया है, अगर उसका डेथ सेंटेंस ऑल्टरनेटिव पनिशमेंट था या उसके डेथ सेंटेंस को हायर कोर्ट ने लाइफ सेंटेंस में कम्यूट कर दिया है, then he has to remain in prison for 14 years actual. It does not matter how many remission he has earned in the jail. So this is the limitation by way of another thing. But if like he was a convict in another, a simple life imprisonment. Death is not an alternative punishment, and that sentence is not commuted into life. Then there is no limit. But again, as per the premature policy, they have given the criteria. For example, simple murder में 10 plus 4. Double murder, heinous murder में 16 plus 4, meaning thereby 16 actual and 6 years remission. So that case has to fit into the policy. Otherwise, earning remissions is not a ground for release of the convict. So, actual sentence plus remissions, they have to, find a mention in the premature policy of the state. I hope your point is clear.
Now, Kartik Kakkar says, can a convict pursue higher education while serving as a sentence?
Yes, why not? As we discussed initially, that Article 21 remains with him throughout his life. बहुत सारे लोगों ने तो जेल से जाके बहुत डिग्रियां हासिल की हैं, एग्जाम्स दिए हैं.
And Varun says, what are the different kinds of paroles and what are the parameters for assessing the different kinds of paroles?
Okay. Paroles इसमें है emergency parole, उसके लिए तो जेल सुपरिटेंडेंट ही लगा देते हैं, दे सकता है. Then there other parole के लिए criteria ये है कि first 1 year में आप parole नहीं ले सकते. First 1 year you have to remain in prison if you show a good conduct and if you make out a case and the jail superintendent informs the deputy commissioner, and if there's a proper report that he's not a threat to law and order, etc., then the parole can be granted. They're like emergency parole is different. Emergency parole cannot be denied. But in most of the cases, parole at times on the basis of law and order situation can be denied.
One is
But अब जो है ना, हरियाणा ने तो अपनी ये parole वाली policy बिल्कुल change कर दी है. Parole rules सब बहुत relaxed हो गए हैं because everybody is of the opinion that the prisoner has the right to remain with the family, and these rules or these acts should not be very harsh on the prisoner.
one of the very rudimentary question, how does Article 39A, right
Yes,
to
yes,
free legal
yes.
aid, practically apply to convicts, especially indigent ones?
So it's a very important question because I forgot to mention these legal right to legal aid. Indigent person, like if we earlier section of CRPC 436, where it have bail in available cases, and if is not able to furnish bail bonds, then after 1 week, then he should be released on personal bond. So the legal state authorities, they are making regular visits to the jail. They are helping the accused in filing the appeal. And if the at times while suspending the sentence, the condition of bail bond is onerous, then there is a poor prisoners fund also, which is a scheme initiated by the state government, that he should be given like 45,000, Tanu, if I'm not mistaken. And we had discussed also that if he's not able to furnish bail bonds, then 45,000 should be given by the state to furnish his bail bonds. So the legal authorities and legal aid and free legal aid, these are quite active as far as right of convict is concerned, because I have seen a lot of legal aid panels regularly visiting the jail premises.
Now, this is, can a convict vote or contest elections while
But that is, he has a right to vote, but not contest election. I think that the petition is pending in the Apex Supreme Court. This issue is pending as far as contesting elections is concerned.
Now,
Yeah.
another question would be, Are
That should
convicts,
be governed by the Representation of People Act, not by these remission and commutation, right?
the number of years, etc. What is your conviction? Are convicts entitled for parole, furlough, remission as a matter of right, or is it a discretion of the authorities?
It's a discretion.
Then, how does a convict pursue mercy petition before the governor or president? And what is the scope of judicial review in such matters?
So I think we had discussed while in the session that once he has exhausted all his statutory rights, like for example, appeal before the High Court, then it's the SLP before the Supreme Court. So after exhausting these statutory rights, what remains is the Daya Yachika, mercy petition. As the name is suggestive, he cannot claim it as a matter of right. These are again discretions, but there are certain guidelines that, for example, it should be decided within a reasonable time. If there is a delay, a long delay, then the convict again by way of Article 32 approach the highest court that it's infringement of fundamental right, and then his death sentence is commuted into life imprisonment.
So thank you, Dr. Deepa, and it was such a wonderful session. It was quite insightful. और जो लोग बाद में भी सुनेंगे तो उन्हें ये पता चलेगा कि कई ऐसी चीजें जिनका लगता था कि इसका कोई समाधान है कि नहीं, वो आज के सेशन के बाद जो कहते होते हैं कि भाई क्लाउड्स ऑफ डाउट हट जाएंगे और we will take further session.
एटलीस्ट ये वाला डाउट में मेरा बहुत इच्छा थी कि हट जाए कि दिन एंड रात दो काउंट नहीं होते थे, क्योंकि मैं जहां भी लेक्चर देने जाती हूँ कि मुझे ये बहुत सुनने को मिलता था.
कंक्लूजन में एक बार फिर ये दिन और रात वाला कंसेप्ट समझ लें, कई लोग एकदम एंड में सेशन में ज्वाइन करेंगे. मैम एक बार वो दैट इज आई अनम्यूटेड धीरज, but could you explain that din and raat concept again, because some people have just joined in?
Okay. So जो लोग ये सोचते हैं ना, फॉर एग्जाम्पल एक अक्यूज है, उसको लाइफ इम्प्रिजनमेंट हुई है, तो चाहे हम आईपीसी पढ़े या गॉडसे वाला जजमेंट है कि लाइफ मीन्स एंटायर लाइफ, ही हैज टू रिमेन इन लाइफ थ्रू आउट हिज लाइफ. इट्स नॉट सो. व्हाई? बिकॉज स्टेट की ये भी ड्यूटी है कि जिन भी प्रिजनर्स को उन्होंने जेल में भेजा है उनको वो सुधार के वापस सोसाइटी में लेके आए. अब वो सुधरे हैं या नहीं सुधरे, इसका क्या क्राइटेरिया है? इसका क्राइटेरिया है जब वो जेल के अंदर अपना कोई अच्छा कंडक्ट दिखाएंगे, प्रिजन में कोई ऑफेंस नहीं करेंगे, प्रिजन में काम करेंगे, राइट? जब वो काम करते हैं, कोई ड्यूटी करते हैं, खाना बनाते हैं, सफाई करते हैं, नाइट ड्यूटी देते हैं, तो उनको एज ए इंसेंटिव कुछ पॉइंट्स मिलते हैं. एंड आई टेल इन अ वेरी सिंपल लैंग्वेज, व्हेन वी शॉप अ लॉट, सो हम उस क्लब के मेंबर बन जाते हैं तो हमारे कुछ पॉइंट्स हम अर्न कर लेते हैं, तो हम जब शॉपिंग करते हैं एंड में तो उसमें से वो माइनस हो जाते हैं, तो 1000 में से 100 माइनस हो गए. तो ऐसे ही जो उसका लाइफ इम्प्रिजनमेंट है, पहले तो स्टेट ने उसको कम्यूट किया टर्म सेंटेंस में, फिर उसमें जितनी भी रेमिशंस उसने अपने गुड कंडक्ट को अर्न करके दिखाई है वो उसमें से माइनस हो जाए. So it's not that day and night 2 counts होती है, it's his good behavior in the jail and he has earned good awards.
समझ गए? वो जो कहते होते हैं, बहुत पुरानी कहावत है, every sinner has a past, every saint has a past and every sinner has a future.
Very good. And I take it further, अगर आप किसी नेशन को अच्छे से जानना चाहते हो तो उसकी प्रिजन कंडीशन देखिए.
ये तो फिर वही वाली बात होगी, अगर किसी की पहचान करनी है तो उसके जूतों की शाइन से पहचाने.
बिल्कुल कि हम कितना, इंडिया कितना सिग्नेटरी है इंटरनेशनल कॉवेनेंट्स, ट्रीटीज एंड ऑल, बट क्या एक्चुअली में ओवर क्राउडिंग हुई है, खत्म? क्या एक्चुअली में इसके राइट आर्टिकल 21 में प्रोटेक्ट हो रहे हैं? दैट इज फॉर दैट वी नीड अनदर सेशन.
फिर वो याद आ रहा है, वो कहते हैं अभी पिक्चर तो मेरे बाकी है मेरे दोस्त, तो ये आप कनेक्टेड रहे, डॉक्टर दीपा सिंह आपको ये सेशंस में और
ये सीक्वल है एक्चुअली, ये फर्स्ट था नेटफ्लिक्स सीरीज में, तो अभी सीक्वल।
वही मैं कह रहा हूँ, अभी पिक्चर मेरे बाकी है मेरे दोस्त। और बिफोर वी आस्क धीरज, क्योंकि आपने इतना अच्छा सेशन लिया कि मेरे को लग रहा है कि ये नहीं बोलना पड़ेगा कि लोग धीरज से आपको सुनते रहे, पर ये बोलेंगे कि लोग उसको एंजॉय करते रहे। पर क्योंकि कंक्लूड करेंगे तो वो धीरज से ही करवाएंगे, क्योंकि
धीरज के साथ
बिल्कुल। पर बिफोर वी
मैं
आस्क,
थैंक्स करना चाहूंगी कि सब लोगों ने मुझे बहुत धीरज के साथ सुना।
नहीं, धीरज के साथ नहीं होता। जब अगर आप अच्छा होते हो तो वो कहते हैं यू आर लाइक अ गुड म्यूजिशियन, यू डोंट अलाउ द पीपल टू अंडरस्टैंड, बट दे जस्ट एंजॉय व्हाट यू आर सेइंग, दे गो विद द theme. And tomorrow's session would be practical strategies for seeking relief under the Specific Relief Act 1963. Your roadmap to effective civil remedies by Sardar Narendra Pal Singh Rupra, a senior advocate from Jabalpur, the same place from where the Honorable the Chief Justice has come. And he has his own session channel. Do join us tomorrow at 6 p.m. And now it's time for Dheeraj to spark his inputs as usual. He has his own flair of giving the insights. Over to you, Dheeraj.
Yeah, now I'm there. Although she has herself made an impact today with the beautiful talk on the rights of convicts, but I will only add by saying to all those who do not know her background, so I'm lifting the veil for everyone to hear. She has a remarkable career at the intersection of academy and legal outreach. Dr. Singh has established herself as a leading criminal expert in criminal law. She had been a star faculty member at the Army Law School, where she had been dedicated herself to shaping the next generation of legal minds. Dr. Singh's commitment to justice extends far beyond the classroom. She has conducted impactful awareness programs to educate prisoners about their legal rights, a crucial effort in promoting fairness within the justice system. Furthermore, I would say her work with law enforcement agencies is equally commendable. She has provided essential training to police personnel on various aspects of investigation. As she told me the other day, that she delivers lectures to various police agencies also. This training has been instrumental in ensuring that the rights of both victims and accused are understood and respected throughout the legal process. So, in short, this is the brief introduction about the ma'am. Though there's much to say, but for today, this would be sufficient, I believe.
Thank you, Dheeraj. Say you are always known for brevity.
Very generous.
No, they say brevity thy wit.
This is what I know about you through you. That's all.
That's what I'm saying. Brevity thy wit is the hallmark of Dheeraj, those who know it. And they say next session आएगा मैम का, आती हूँ थोड़ा सा धीरज धरो. चलो. Thank you, and we will connect shortly. But do join us tomorrow at 6 p.m. Namaskar, Jai Hind, and enjoy the Constitution journey.